Good evening, this is Laws 11057, Introduction to Law. We're now into week 8. We're dealing with the issue of professional ethical behaviour, and it's based on the New Lawyer, Chapter 13. In addition to that, I had posted some homework to do, and that's all about reading through the Australian Solicitors' Conduct Rules. What I'm showing you now, which I've shown you last week, I think, is a publication by the Queensland Law Society. It is a publication which costs a little bit of money, but it is well worth spending the money, and it's something that you can take into the exam with you. I would urge you to consider getting that, or at least try to access some of that information. But I will show you something on the Law Society which might help you if you haven't already found it. In addition to what I've just shown you, while I'm on the topic of the Queensland Law Society, can I urge you to consider student membership? It will make you feel part of the profession. It will give you some insight, and you can obtain this booklet through the Queensland Law Society, or you can enrol, you can register, I think, online as well. So it's a modest fee to do that, but it will give you an excellent opportunity. I guess if I have some regrets in my career to date, one of them probably is that I didn't get more heavily involved from the outset. It's fair to say that I'm pretty heavily involved in a number of things in the profession now, but there's no reason why I couldn't have started that when I was in my 20s. I did to a degree, but not to the degree that I would like in hindsight. So I urge you to get involved and participate. If you have an opportunity to do something, follow through. It's really interesting looking at the assignment number 2, and thank you for the work that's come through. Generally very high standard, and thank you for being on time. Now, without giving too much away, it was very interesting for me to read the choice of legislation from individuals because it gave an insight as to their particular interest and in some cases their ambitions in law. And it is a good idea to try to focus your attention if you can. We talked about this in week 1. Try to identify an area that's of interest and make some contacts. Make yourself available around the courts. Try and speak with some barristers. Speak with some people in industry. Make some contacts. For example, those in Hervey Bay would be aware that I'm very happy to have people come along to the criminal law courts and simply spend time with me as I'm proceeding, or through the Legal Advice Centre. So there are opportunities like that, but you need to embrace those opportunities and get yourself involved. So the Queensland Law Society is a great way to do that. Now, if there are any questions, please come in live, just unmute your microphone, or ask through the chat facility. So the homework that I gave you last week for this week is all about referring to the Australian Solicitors' Conduct Rules and also the Barristers' Rules. And you need to be aware and have a good working knowledge of either or both of those things. So the fundamental duties of lawyers are contained in those documents, and you will see that there are certain duties to the courts, certain duties to clients, and certain duties to your colleagues generally. All of that needs to be put in the context of a working life where you have an overriding, well, you have a duty, I won't say overriding, but you have a duty to your employer as well. And it's really a balancing act. To do things properly, ethically, and do the right thing by your employer, or if you're self-employed, for yourself, you need to ensure that you don't cut corners to the point where you are not complying with the rules, but equally, you can't afford to be bogged down in dealing with the rules to such a degree where you don't get your work done. Now, I'm not advocating that you avoid complying with the rules whatsoever, but what I am saying is that you also need to get on with the task, and that's only being fair to clients and being fair to your employer. So keep that in mind, that there is that practicality. And in your exam, you may find that there's a question in relation to how you would cope in circumstances where you are in fact employed perhaps as a first-year lawyer, and you're faced with an ethical dilemma. You need to bear in mind you've got to get on with the job, you've got to do the right thing for your employer, but you've got to follow the appropriate rules. So that means understanding the rules and doing so in the context of a real-life employment situation. So in addition to the fundamental duties which are contained in Rules 3, 4, 5 and 6, there are a number of rules that deal with the relationship that you have with clients. That's Rules 7 through to 16. Have a look particularly at Rule 8.1, and then the rules, this is the solicitor's conduct rules, go on to talk about advocacy and litigation, Rules 17 to 29. And you'll see in there that solicitors have a duty to the court process, to their opponents, to witnesses. There are certain special rules that apply to cross-examination of certain witnesses. Prosecutors have different duties. Prosecutors are required to be model litigants. What that means is that always prosecutors need to consider presenting all of the material in a balanced way, in a fair way, even though some of that material may not be directly advantageous to securing a conviction in a criminal law situation. So be aware of the rules relating to model litigants and think about how the role of a prosecutor from an ethical sense can differ from the role of, say, a defence lawyer. So think about those aspects as well. Rule 21.2 says that solicitors must take care to ensure that decisions by the solicitor to make allegations or suggestions under privilege are reasonably justifiable and appropriate for the robust advancement of the client's case and not made just to harass or embarrass a person. So if there are any questions about the rules, now would be a good time to ask. And while you're thinking about those questions, I'm just going to mention something that has come in today, in fact, from the Queensland Law Society, and I receive updates on a regular basis. If you're in a position to do so, to obtain updates from legal sources, I encourage you to do that. We've already spoken about Jade Barnett. I hope that you're all subscribing. But from the Law Society today, there are some issues in relation to ethics. I'll come to those shortly, but before I do, the lead story, if you like, is the swearing-in ceremony for Chief Justice Catherine Holmes is going to take place this Friday, the 11th of September. That's at the Banco Court, and there will be refreshments in the gallery outside the Banco Court. So if you happen to be in Brisbane, it may be worthwhile trying to sneak a peek at the proceedings to see Her Honour being sworn in. There's also nominations for council elections, and you have an opportunity in the profession to join as a member of the QLS Council. And again, I'd urge you to consider those sorts of things, or to be part of the committees that are run through the Queensland Law Society. Okay, enough being off topic, back to ethics. In the material I received today from the Ethics Centre at the Queensland Law Society, there's a quote, and it comes from a decision in New South Wales 2011, McLaughlin against Dungowan, D-U-N-G-O-W-A-N, Manly, Pty Ltd, number 3. It's a 2011 NSWSC decision, 717, where at 30, the court said the following: it needs to be emphasised that the efficient conduct of commercial litigation, indeed all litigation, can only be assisted by restraint, moderation, sensible cooperation and sound judgment. Indeed, the due administration of justice demands it. This is part of the wider duty to the court. So keep that in mind. You probably can guess that there'll be some sort of question about what you're going to do in a practical sense to ensure that you stay on top of things. You have this overriding duty to the court, to the clients, your employer. The court in McLaughlin has provided you with some guidance as to what's expected of you. So I'm going to ask myself, and I'm going to ask you to ask yourselves now, what are you going to do in a practical sense to ensure that you do comply with that overriding wider duty as referred to and that is to act in a way which is restrained, moderated, sensible, cooperative, and sound. It's all very well to say these things, but what we don't want is for you after the event, after something goes wrong, to think, oh, I should have done that. So you've got to try and plan ahead as to what you will do to ensure that you fulfill those ethical and other obligations. Just finally, from the QLS update, there's an ethics tip. And retired Major General John Cantwell has said that with respect to leadership, good leaders take time for reflection. When concerned by an ethical dilemma or problem, taking time to reflect and think ahead is important. I really like that quote, because what it suggests is that when you're in a position of authority or responsibility, you will need to build in some time for reflection. And when you're dealing with an ethical dilemma or problem, you do need to ensure that you take time to reflect and, importantly, think ahead. And that's what I'm asking you to do now. Think ahead. How are you going to make sure that you do, in fact, take time to reflect when needed? What will be some of the practical issues that you'll consider in that regard? Okay, any questions? We're all very quiet tonight. Well, I'll continue. What I think I might do is share the screen for a while, because if you haven't had a look at the Queensland Law Society webpage, then I would certainly urge you to do so. It's important for a whole range of reasons, and one, of course, practically speaking, is the exam. So let me call up the internet and share the screen. No questions? Nobody's found it difficult dealing with the question of ethics? It's all simple? All right. You will need to know all this for the exam, of course. Okay, so hopefully you can see my screen now. Let's have a look. Queensland Law Society, and we'll go into have a look at the homepage for the Law Society. You're hopefully all familiar with that. I go up here to log in, but down here, this is what I want to show you tonight, QLS Ethics Centre. Now, I haven't logged in as a lawyer, I've just logged in as a member of the public. So hopefully everything that you can see on your screen here now is available to you. And there's some great information here. This is a very important resource. Number of resources down the bottom. Let's have a look at this one. Client instructions and capacity. That looks interesting. So it refers you to the relevant rule in the ASCR. It talks about the legal test for capacity in various circumstances. Oh, look at this. This looks interesting. New legal capacity handbook for practitioners. See what that says. And it says here that practitioners can access it here. Well, let's just see if it allows us to practice, even though I haven't logged in as a practitioner, but let's just see if I can find it. And here it is. I hope. It's quite a document. So if you can see my cursor down the bottom, the PDF is coming up. And there we have Alan's Linklaters have prepared this document in conjunction with the Queensland Advocacy Incorporated and Queensland Law Society, and that's the Handbook for Practitioners on Legal Capacity. Now, why is that important? Because when you're taking instructions, you need to ensure that your instructions are taken appropriately. And I would urge you to have a look at this document. This course is not a course about legal capacity, but there are some really important issues. For example, here, the presumption of capacity, and that is essentially that every adult is presumed to be capable of making decisions unless the contrary is determined. And this type of work comes into my role at QCAT as well, where as a member, I spend a lot of time hearing matters in relation to issues of capacity and the potential appointment of guardians and administrators. Okay, so that's the Queensland handbook in relation to capacity. Let's just go back here to the ethics page. You'll see there's a whole lot of information here about witnessing enduring powers of attorney, determining capacity. That's Claire Endicott, senior member at QCAT. So have a look through that, and I'm sure you will enjoy that if you haven't already done so. There's a lot of good information there. Let's go back a page or two, and we'll see what else is there. This is important. Stafford Shepherd. I've been liaising with Stafford in the last couple of days about what information we can provide on the website, and I've got permission to do some of that, so I'll be uploading some material. But look, Stafford is a great tweeter. I don't tweet. I'm not a follower, and I'm not a tweeter, but Stafford is. So why not follow what Stafford has to say in terms of ethics? And you'll find that Stafford is the guru in terms of all things ethical. And if he says something, you can take that as being said with great authority. You'll see here some discipline updates. So you'll see the Legal Services Commissioner. Those decisions are through QCAT as well. So that's an important area. Lots of resources over here. Some frequently answered questions. Here's the conduct rules. I've suggested that you can buy them with the commentary, but you can also access the rules as a PDF, and we're just doing that now. But I've also uploaded that. What this doesn't have is the case law commentary. So in the paid version, which I've commended to you, you'll see, for example, that there is references to case law and commentary, which doesn't appear in the bland rules themselves. Okay, are there any questions? We must have some questions about this. Do you want to know what you need to read for the exam? Or we're right with that, we'll just read it all. Okay, so understand your obligations generally to the courts and to the clients and others. All right. Okay, thanks, Nick. Nick says you can open it in your iBooks on your iPad. Thank you. Now, I hope that you've all had a look at the video with His Honour Judge Dean Morzone. Judge Morzone was very generous with his time. At that time, he was not appointed. He's been more recently appointed, but some tremendous things which were said there. Oh, Rebecca says, is there a specific section we need to focus on for the exam? Well picked up, Rebecca. You'd have a look at capacity, that there's a reasonable chance that may be on the exam. And also just think about it in the context of you being a first-year lawyer and you're being asked to do something. All right. Have a look at the bench books. Bench books are terrific. They're often used by judges in explaining how various aspects of the law are explained to a jury. I'm not sure if I can find this quickly, but I'll try. Bench books. You can find the bench books through the Queensland Courts page. And I'm just, as we've been speaking, you heard me say bench books, so you can see how quick it is. I'll share the screen again. If I can find the button to do that, which I am now. And you can see there the bench books. And these are terrific because they give you a bit of an insight into what the court might say. So during the trial, the judge may have cause to give a direction to the jury in relation to an issue of fitness for trial. So let's just have a look at that one. And this is, if you like, a script used by a judge when addressing a jury in relation to certain things. And this is to do with capacity, as to whether that person is able to make an appropriate defence. So fit to stand trial, usually determined by the mental health court, but there are other things that can apply. And that's what I did today in the Magistrates Court. It's a Section 83A application. as opposed to an application of the mental health court. Okay, so Benchbook's really good resource. Have a look at that, and it'll be very handy when you're doing criminal law. So, for example, the rule in Jones and Dunkel is explained there. So that's a situation where someone who you would think should have been called is not called, and the court will then address the jury as to what they can make of that. So that's what we call the rule in Jones and Dunkel. And that is, it's not always given. So have a look at those Benchbooks, and there's a lot of really good material out there. It's just a matter of looking and knowing where to look. If you do find some good information, why not share that with your colleagues in UCrew? I'd really appreciate that. Okay, where did I find it? Yeah, the Benchbooks. This is Queensland Courts. You heard me earlier just say Benchbooks off screen. That's when I just Googled it. But it's officially the Queensland Courts website. And down here, where can we find Benchbooks? Sorry. I don't think it's in here. I didn't do a very good job then, did I? Oh, you're looking at me, aren't you? I'll see if I can go across to the share screen again. Sorry. So we went to Queensland Courts, and the Benchbooks can be found on this page. Exactly where you find the Benchbooks, sorry, is something I'm looking for now. So there's judgments. You're probably all familiar with that part. Should be. Yeah, and I just Googled as well. So for lawyers, thank you.
John, if you click on the for lawyers section, that's where it is.
Yep, great. Oh, there they are, Benchbooks and UCPR Bulletin. That's excellent. Thank you very much. So there's the Benchbooks. Thanks, Nick. Otherwise, if you just Google, you'll get there as well. And it's amazing how much information you have now at your desk. And you can just imagine how wonderful all this is compared to what it was like in the 80s, where we just didn't have any of this. Okay, so thanks for that contribution. I'll stop sharing the screen there. And let's now talk about ethics a bit more. In your text, pages 435 to 455, you can just read that for interest and context. For courtroom ethics, have a look at what Judge Morzone had to say. I just want to talk about the layout of a courtroom and what happens in a courtroom generally. It does vary, and you would have seen some discussions in UCrew about this. From state to state, obviously it does vary. So I'm just familiar with the Queensland context, particularly in relation to criminal law. But generally speaking, in a magistrate's court, what you can expect as you walk in is, firstly, no provision for a jury. So there's no juries in the magistrate's court. You've got the bench, of course, for his or her honour. In front of his or her honour will be provision for the clerk assisting the court. And then, of course, before that, you have the bench, the bar table. And at the bar table, typically, in my experience, prosecution will be to the right and defence will be to the left. So in your first court appearance in the magistrate's court, firstly, as a precaution, I would urge you to go and check it out well before your first court appearance. And that probably means trying to spend some time with a practitioner. And who knows, if that practitioner is well known in the court, he or she may invite you to meet with the magistrate. And quite often magistrates are happy to meet new practitioners or law students, and that'll give you a good feeling of being involved as well. So sit at the left-hand side. In the magistrate's court, your client will normally sit beside you. That is provided they're not in custody, but they'll normally sit to your left. So my practice is I sit on the left-hand side of the bar table, but if you like, I'm on the middle part of the left-hand side, and my client is to the left. To my right is the prosecutor, and if it's a children's matter, we might have the Department of Youth Justice involved, and that representative would sit between me and the prosecutor, who's on the right-hand side. District Court is very different. In the District Court, you have the same layout of judge. The person sitting before the judge, below the judge, is the associate, the judge's associate, and then of course you have the bar table. Generally speaking, it'll be the same layout, prosecution to the right, defence to the left, but always if you're acting for a client in a criminal matter in the District or Supreme Court, what you do is you make arrangements for that client to be put in the dock before the judge walks in. So effectively, they become a prisoner of the court immediately, and they then have to be released by the court. So it's very different to the magistrate's court, where you will not automatically put your client in the dock. And when I mean the dock, I mean into, if you like, into custody. But in the District Court, they go into custody. Logistically, I try to position the client in such a way that I can look across and see the client, and I think that's important. To prepare for your first magistrate's court matter, it's really important that you prepare the client. And that means making sure that you've discussed with the client what to wear, how to act, demeanour, what are the steps. And this is what you need to know in terms of preparation. In the District Court, matters proceed by way of indictment, and an indictment is really just a piece of paper saying this is what this particular person is charged with. Sorry to finish that sentence with a preposition. The charge is read by the associate and the client enters a plea, guilty or not guilty. Always encourage your clients to say the words, Your Honour, after anything that they might say to his or her honour at the bench. Okay, so any questions about the layout of the court, where people sit, what you need to say to your client before you walk in? Any of those issues? Nice and simple. It's all part of good preparation to know these things. Okay. In terms of procedure, in civil, it's a matter of the plaintiff presenting or the applicant presenting a case. The witnesses are called, and the lawyer calling the witness will go through the process of examination in chief. Examination in chief is really where the lawyer will ask open-ended questions, allowing the witness to respond. And the children's lawyer, going back to children's matters, doesn't always necessarily have to sit in the middle, but in my experience, that's where they typically will sit. Okay, so we've got a case. Case has started. The lawyer has called his or her first witness, and that witness needs to answer questions and provide evidence. In that examination in chief mode, the questions are open-ended. Does anyone give me an example of an open question as opposed to, not surprisingly, a closed question? So what's an example of an open question? Explain to me. I like that. That's good. How would you define that? Yes, that's great. Can you tell me what happened? Like that as well. I can't read that, Doris, so I don't. Starts with who, how, yes, what, how, who, etc. Question does not result in a yes or no answer. They're excellent answers. Thank you very much. What did you do? So they're really open questions. They're not leading questions at all. So the general rule that if you're calling a witness in examination in chief, you must avoid a question which could be answered with a yes or no. Now in cross-examination, it's entirely different. And you can ask questions that can be answered with a yes or no. So let's say you are acting in a criminal law matter and you're defending a client. We need to think about how you would prepare for that. It's your first ever trial. The client wants to know what's going on. They want to know about the procedure. They want to know what you're going to do, what they have to do, etc. They're saying, the client says, he or she says, not guilty. How do we prepare for that? All right. So the first thing is that you need to explain to the client, of course, that the prosecution needs to establish beyond reasonable doubt that the client is guilty. It follows from that the client need not say anything. The client is under no obligation to make any statement in the initial stages when spoken to by police, and they're under no obligation to give evidence in a court proceedings. And theoretically, and in reality, nothing can come of that. But what if your client says, I do want to give evidence? Well, you probably want to give your client some advice. One of the things that you might want to do is say, under cross-examination, you are going to expect to be hammered. The prosecutor is going to want to go at you. So be ready for that. Do not cave in. Do not show a lot of emotion. Do not respond angrily or in an impatient way, because if you do that, then the prosecutor's winning. Make sure that you listen carefully to each question and answer once you know what the question is. If you don't hear the question or you don't understand the question, then before you answer or purport to answer, ask for it to be asked again. And when you're under cross-examination, good answer, Scott, short, simple answers. Nothing can embarrass a prosecutor more than a circumstance where there's a very long and involved question met with a simple no. And that's it. Prosecutor then has to gain some momentum, get some traction again, and get going. So if you like, for those of you that might be cricket-minded, those batsmen or batswomen, I suppose these days, but those batters that are very defensive will just block, block, block. That's kind of the mindset that you want to adopt if you are subject to cross-examination. Generally speaking, I'll say to my clients that if I'm putting them in the witness box and I ask an open-ended question, it's an invitation to just tell me as it is. You don't, not quickly, not hurriedly, but just tell me what it is. But if the other side is asking you questions, then just yes, no. If you can get away with that, just leave it at that. Okay, so that's all part of the advocacy. And if you act intimidated, they will eat you alive. Yes, thank you, Meg. All right, are there any questions then about conflict between professional and personal ethics? You probably need to know this for the exam as well. Have you done some reading about that? Matt, while we're doing that, Matt says, what if no is a lie of omission? Yeah, you want to be careful. If you go into the witness box, you want to really be very well prepared for it. If in doubt, don't go. Okay, so what about dealing with conflict between professional and personal ethics? Are we ready to answer a question in the exam about that? Someone says to you, I want you to defend me in relation to this allegation of child molestation. Do you take on the job? I can tell you what I do. I have dozens of them. So yes, I take on that job. But would you take on that job? Yes. Someone says, I've been charged with indecent dealing with a child. Would you represent me? I've got a yes, yes, a hell no. What if your boss says, I need you to take this case? Only if you can do it unbiasedly. Yes. There's always two sides to the story. Yes. There'll be a quit. Everyone's innocent until proven guilty. I like these answers. I like the honesty as well. You've got to be prepared to do the work. And of course, can I just put this to you? If you, and I'm not saying it's wrong for you to say, I don't wish to do that job. That's fine. That's entirely your prerogative, because you may lose your job as a result of that. But it is your prerogative, of course. But the question, Kimberly's raised the question, is it reasonable to turn a client down? We don't have the cab rank rule as solicitors that we do as barristers. That essentially, it's a bit antiquated, but what it really means is that barristers don't have the luxury of turning down a job, solicitors do. But you can say, no, I don't want to take on the job. But I just pose this. Are you therefore assuming that you are the judge and the jury? Is that your job, to make a determination? Isn't your job to present the case? I mean, if you form an opinion that the client you're representing is actually guilty, I mean, is it fair to say, well, who cares? What has your opinion got to do with it? It's got nothing to do with it, don't you think? I mean, your job, do you know? Do you care? Have you seen that movie called Primal Fear? It's got Richard Gere and Ed Norton in it. If you haven't seen Primal Fear, have a look at it. It's great. But anyway, you're there to provide a service. Yeah, great film. The opinion matters really not the slightest, says Nick. That's good. You're there to provide the legal service. Now, if you're... Good question, Letitia. What if your client has already said they're guilty? Does that mean that you can only act if it is a plea of guilty? Your client says, I am guilty. Can you please represent me? The question is, must you therefore only be involved in a plea of guilty? No, no, no. Good. No. That's the correct answer. So, yes, you can take the matter to trial, even though you know the client is guilty. You've got to be careful, but you can. And the reason for that from a theoretical point of view is quite simply this. Go back to basics. Your client is under no obligation to prove anything. Prosecution must prove every element of the case beyond reasonable doubt. So the saying that we use here is that in those circumstances, we're putting the prosecution to proof. We'll just see if the prosecution can prove it. What you cannot do in those circumstances is suggest something in your questioning which indicates that your client is in fact not guilty. Let me go through that again. Prosecution have to prove the case, but you can't exactly, Scott says, such as an alibi, but you can't therefore go in and say, yes, but my client has an alibi, or something along those lines which you know to be incorrect. You can't do that. But by all means, you and your client can essentially sit back and see if they can prove it. There's nothing wrong with that. Okay, so you'll need to consider that question about a conflict between your personal ethics and your professional ethics. According to the traditional view, a lawyer must act in the best interest of a client, even if doing so is inconsistent with their own personal views. That's the traditional view. The alternative view is that one of responsible lawyering, which emphasises your role as an officer of court and trustee of the legal system. And Parker and Evans favour an ethic of care over other approaches, adopting a more holistic approach. So be prepared to discuss some of those issues. All right, just generally speaking, I'd like you to consider university policy. You can access that policy through the website. Has anyone had a look at policies for the university? And I'm saying all this in the context of ethics because we've talked about plagiarism, yes, Humsey Hancock, etc. We've talked about misconduct, thank you. So some people have had a look at it. You need to consider your ethical duties as a student of law, and you know from that first assessment that these things can come back to affect you at a later time. So do ensure that you have a look at university policies. Perhaps have a look at other university policies if you can access them. Griffith University policy has some issues in relation to collaboration. So maybe think about that issue as well in that broader context. You would have seen on the video that I did about undertakings given by lawyers. And that came about as a result of what's called Ethics Statement Number 1, Undertakings, which was published in February this year. And that talks about the role of undertakings, what undertakings mean, the difference between an undertaking given by a solicitor personally and an undertaking given by the solicitor on behalf of a client. So you need to be aware of that difference. And you need to be careful in practice not to make a mistake. So for example, if there is an issue where money needs to be paid at a later time based on a certain event, then as a lawyer, if you say, I undertake to pay that money, if this occurs, well, guess what? You have just personally committed to doing it. It doesn't matter if you then say, oh, I meant to say, assuming, of course, that my client gives me the money. As a lawyer, if you give an undertaking, you're it. That's it. Too bad. So sad. Come up with the $200,000 because you undertook to pay it. The difference is that if you say, I undertake on behalf of my client to pay the $200,000, then what you're actually doing is you're saying the undertaking is from the client, and you need to be careful in giving the undertaking, and equally you need to be careful in receiving the undertaking to ensure that your client is adequately and appropriately protected in those circumstances. So just by a show of hands, have you had a look at that video in relation to undertakings? I'm just putting you on screen now. Yes, has everyone had a look at it? Some? No, not so many? All right. So do have a look at that. And next week is week number 9 is feedback week. It's also brainstorming week. Now, by feedback week, what I mean is that I would really like you to tell me how you're going with this course. I'd like you to tell me how the assessment has been, whether we've covered what the sort of things that you'd like to have covered. Are there things that you want to cover? Because I can still maneuver the course around a bit. So feedback week, and I'll invite you to be candid in your comments and look forward to it. The other thing about brainstorming is that I'm now going to think about, I'll ask you to think about how you will give advice to a client, perhaps in a holistic sense, and put yourself in a situation where the client comes to you with a problem and you have to come up with an appropriate solution. When I was doing university, perhaps in the 70s, it was all very legalistic, and that is, for example, this is a contract dispute. The remedy for seeking a redress is to make an application for an order of specific performance. So that was the problem, that was the answer. These days it's very much different. We look at a whole range of options, including alternative dispute resolution. So part of your job for next week in brainstorming is coming up with a whole range of different options that you think might apply in certain circumstances. So I'll post something on the website for that. Okay, well, that brings us to an end for this evening. Are there any questions before we close? Thank you for attendance. I'm sorry I've done so much talking. Just going back to personal professional conflict of ethics, say we answered a question with no, personal ethics would prevent me from doing that. What would be an incorrect answer? Would that be an incorrect answer? So if no, look, I think it's fair to say that you're always entitled to say to a client, I don't wish to take the instruction, I can't do that. And it may be that by being candid with the client to say this is not an area that is of interest to me or that I feel comfortable with, the client may feel that they're better off getting other representation anyway. So that might be a good question to or a topic to raise with the client. But simply saying, no, I don't wish to take on this task is not of itself unprofessional behaviour, if that's an appropriate answer to that question. Okay. All right. Well, I'll stop the recording now. Thank you very much for your attendance, and we'll see you next week.